Here with me there is Michale Sevel. He did his PhD in philosophy in the Texas University with a dissertation entitled Essays on Authority. And his advisors were Brian Leiter and John Dees. Now he has a postdoctoral fellowship in the European University Institute in Florence, and he will be visiting professor in the law school of the University of Miami next year. Today he's ready, I hope, to present and discuss with us his paper, Knowing the Law. Now, thank you, Michale, and it's your time.
Okay. And roughly 40 minutes, is that right?
Yes.
Roughly 40, okay. So, thanks very much for having me. Thanks for coming. This paper is very much a work in progress, and I'll be talking through some parts of it and reading others because it's too long for the time we have today. So thank you for coming and helping me think through some of these issues. So when one surveys the work of legal philosophers over the last 200 years, one is struck by a certain unity of purpose. For every one of those writers seemed to be guided by one overarching question: what is law? This was clearly Bentham's question, in which he answered with an elaborate definition. Similarly, Austin took himself to be giving an account of the essence or nature of law. Later, Kelsen was quite clear that his, quote, theory attempts to answer the question what and how the law is. And when Hart claimed that what is the nature or essence of law is the recurrent question in the history of philosophical reflection about law, he not only said something true of the past, he also played a major role in making it true of the next half century of theorizing. Following Hart, Joseph Raz has always seen himself as investigating the nature of law, and other legal positivists have followed him. This orientation is clearly shared by non-positivists writing after Hart. Fuller is also after the essence, what is essential to law. Dworkin frames his entire theory in terms of the question, what is law, which is the title of the first chapter of Law's Empire. And I think non-positivists such as Finnis, Alexie, and Murphy also take this question as a dialectical starting point. Lately, while the question has remained the same, the terms of the discussion have taken a more Baroque turn. Mark Greenberg thinks that the primary task of legal philosophy is to give an account of legal facts, that is, quote, the determinants of legal content. Shapiro aspires to theorizing about the metaphysics of law. Some writers even see themselves as engaging in the ontology of law. It's no surprise then that what is law has become, as Brian Bix recently said, the standard question of legal theory. In the face of this long-standing methodological solidarity, we should be reminded that when philosophers go about their business, they can take one of two approaches to their subject, both of which have a venerable history in philosophy. One approach is represented by Socrates in Plato's dialogues. Concerning the thing under discussion, he always asks, what is it? Right? And this question motivates all subsequent investigation. We might call this the metaphysics first approach. This view, which runs through Greek philosophy more generally, perhaps finds its clearest expression in Aristotle, who thought that philosophers are properly concerned with what exists and why. He even called the very study of existence first philosophy. The other approach, however, starts with a different question about the thing under discussion. How do I know it? This tradition, which we might call the epistemology first approach, is best represented by Kant, who sought to critique traditional metaphysics by trying to give an account of how our knowledge of the world is possible and what are the limits of what we can know about it, and then to see what the world must be like in light of those limits. On this approach, one begins by constructing a theory about how one gains epistemic access to the thing or phenomenon in question, and only then speculates about what the thing must be like or could be like in light of the nature of how we know it or know about it. Legal philosophers, it seems to me, have clearly all preferred the metaphysics first approach. That is, they're all motivated by the question, what is law? And have allowed their answer to it to partly determine how they answer virtually all other philosophical questions about it. In particular, giving an account of what law is just assumed to be prior, both logically and explanatorily, to giving an account of how we know what the law is. John Gardner, for example, takes for granted that the basic strategy in constructing a theory of law is as follows, quote, one needs to begin by asking what property or set of properties all legal systems have in common that distinguish them from non-legal systems. Only when armed with that information can one identify legal norms, including laws, as legal norms. And Shapiro has recently claimed, and this passage is on the back of your handout, which I'll come to at the end again, because legal judgments must track legal facts, a theory that tells us which facts ultimately determine the content of the law will be essential for a theory that tells us how to discover the content of the law. As a philosopher might say, the metaphysics of law has a direct bearing on its epistemology. Apparently guided by the Socratic thought that one must first have an account of a thing before one is able to identify particular instances of it, positivists and non-positivists alike have thought that we must figure out what law is before going out into the world and reliably identifying particular laws and legal systems. In this talk, I would like to question this familiar approach. I'll try to show in a moment that as a result of taking this approach, the leading theories of law, including Hartian and Dworkinian theories, entail deeply implausible accounts of how we come to know the law. I'll then suggest that perhaps some progress can be made if we put all the metaphysical speculation to one side and begin with the question, how do we know the law? I'll therefore take up an epistemology-first approach to see if by doing so we can come to a more comprehensive theory of law, one which gives equal concern to both its metaphysics and epistemology. The basic idea of the rudimentary account I will give of how we know the law is a seemingly unremarkable one, roughly that in almost every case we gain knowledge of the law by being told about it. But with such an account in hand, the hope is that we can begin to understand the complex relationship between what the law is and how we know it. And there are additional reasons to want a worked out theory of how the law is known. First, insofar as knowledge is normative, knowledge of the law is as well, and in a way not countenanced by the usual discussions of the normativity of law, which almost always focus on whether the law is a source of reasons or obligations for action, not belief. It would second help us understand better the ideal of the rule of law, one important component of which is the requirement that the law is public or publicly knowable. Third, it would help us sharpen our understanding of the separability thesis, which it is said divides positivists and natural law theorists, by allowing us to compare how we know the law with how we know morality, to see if there are any fundamental differences. To be sure, such a comparison would not dispose of the issue, but it would surely advance our understanding of the complexity of the possible necessary relations that may exist between law and morality. So here's how I'll proceed. So after defining more precisely what I mean by knowing the law, I'll take a critical look at some of the views held, often implicitly, by Hart and Dworkin about how we come to know, or in some cases have to figure out, the content of the law. These views, I argue, are all problematic and show the deficiencies of a metaphysics-first approach. And then I'll finally turn at the end, in an outline sort of fashion, to giving a theory of legal knowledge unconstrained by any view about what law is, and conclude with a few speculations about how this account could usefully inform a theory of what law is. Okay, so I've spoken of the need for a theory of knowing the law, but the phrase itself is ambiguous, owing to the familiar distinctions legal theorists often make about what one could mean in talking about the law. For example, we may wish to speak of a law of a particular jurisdiction, the law in a jurisdiction within a particular doctrinal domain, like contracts or employment or something, or law in the broadest and most abstract sense, as a kind of social and political institution that's existed in different cultures across time. So one issue that I do not intend to address here is how we come to know the best or the truest or the true legal theory. Okay, for example, whether a theorist of law must take into account certain moral facts or engage in moral reasoning in constructing their theory. Theories of that sort abound, and is indicative of the recent methodological turn in legal theory. I want to put that aside. Nor am I after a theory of how we come to know a law in a given jurisdiction. That would require us to take up a view of what a law is, which of course would bring us back to the metaphysics first approach that I'd like to set aside for the moment. Nor again am I interested in an account only of how we can know the law in a jurisdiction on a particular subject matter or area of law, for example, the learning that goes on in law schools or in the legal research activities of judges, lawyers, so forth. The inquiry is about such knowledge, but it's broader than that. So in what follows, I will assume that to know the law is to know what Dworkin calls a proposition of law. Dworkin defines these as, quote, all of the various statements and claims people make about what the law allows or prohibits or entitles them to have. This is slightly too narrow since there seem to be knowable propositions of law that do not fit into these categories. For example, a claim purporting to supply a legal definition. So for example, the proposition in the United States, a vessel includes every description of watercraft or other artificial contrivance used or capable of being used as a means of transportation on water, is a relevant datum in the following discussion because it's simply a statement about the content of the law in a particular system, okay? Namely the United States. So the topic here is about how we know claims attributing virtually any content to a particular legal system, regardless of whether on our best theory of law, whatever that ends up being, that content amounts to one complete law, more than one, or only a fragment of one. Okay? So one doubt at the outset about the theoretical interest of the desideratum here is that it amounts to what Bentham called local jurisprudence. That is a theory about how we come to know the law in a particular system. Spain, Texas, Paris, whatever. But while it's true that when we have knowledge of the law, then necessarily, I think, we have knowledge of the law in a particular actual legal system, this doesn't by itself foreclose the possibility of a general account of how anyone ever acquires knowledge of the content of a given legal system. The sort of account of knowing the law I have in mind is general in precisely the sense in which Hart, in the postscript, claims that his theory is general. His theory is, quote, not tied to any particular legal system or legal culture, but seeks to give an explanatory and clarifying account of law as a complex social and political institution. This institution, in spite of many variations in different cultures and in different times, has taken the same general form and structure, though many misunderstandings and obscuring myths calling for clarification have clustered around it. End quote. So in the remainder of this talk, I'll be seeking a theory of how we come to know the law or any legal content that is general in just this way. So I'm looking for an account that gives the general form or structure of how persons come to know legal content. Okay, so before sort of theorizing about that, we should look at a couple of theories about this that I think we find often implicitly, right, in the writings of Hart and Dworkin. I'll take these as examples. So I'll talk through this fairly quickly, since I hope this is familiar to at least most of you. But on Hart's view, how do we know some particular bit of legal content in a given legal system? Well, it seems as though the answer he gives is that we know that content by knowing, first of all, the rule of recognition, right? Remember that the rule of recognition is serves as a remedy to uncertainty, right, in pre-legal societies. And so the idea is that if we knew the content of the rule of recognition, then we could go out and look for rules that satisfy the criteria of legal validity satisfied in the rule of recognition. Okay. How do we know the rule of recognition? Well, we have to observe, since the rule of recognition is a social practice among legal officials, we have to observe the behavior, the words and deeds of these officials to figure out what obligation they see themselves under in terms of what rules to apply in the system. I think Hart's answer is a bit more complicated than that, given this distinction between two kinds of statements he says we can make, both about the rule of recognition and statements that presuppose the existence of the rule of recognition. And this is the distinction between external and internal statements. Okay, so external statements are descriptive statements made from the point of view of an observer, he says. They are truth-apt, what philosophers call truth-apt. They can be true or false as descriptive statements. Okay, then there are internal, right, legal statements, which are normative, made from the point of view of participants within the system. And if we take a recent interpretation of Hart as plausible, namely that he was a non-cognitivist about legal judgment, about internal legal statements, then we're committed to saying that internal legal statements are not truth-apt. That is, they are neither true nor false. Okay, if he's a non-cognitivist in the classical sense. If that's true, it seems to me that the view we get from Hart as to how we know the laws of a given system is by way of the rule of recognition, but that the startling consequence of Hart's view is that we can only know the content of a legal system as an observer. That is, as a participant in a legal system, we can't know. The law is essentially unknowable given his non-cognitive interpretation or understanding of internal legal statements. I hope I'm wrong about that, but that's my reading of him so far. Two things to say about this. Well, the first objection is based on the last thing I just said, which is, well, it seems it's a bizarre view, right, to based on this distinction of internal and external statements, that we can't know the contents of a legal system as participants. Well, it seems like participants, you'd want to say, participants are just the people who need to know, right, the content of a given legal system. But it seems like on Hart's view, the statements that they express, that they use to express their apparent beliefs about the content of a system can't constitute knowledge because they can't be true or false. Second, it seems to me the rule of recognition, the knowledge of the rule of recognition is not a particularly practical tool by which to know legal content. My first experience with jurisprudence was with Brian Leiter at the University of Texas, and in his introductory course with law students, he spends one day for about 45 minutes of trying to articulate the rule of recognition of the United States. And it takes about 40 minutes because it is extremely complex, and if I remember, he left some things unspecified, and there was much more to say. But one leaves that exercise thinking, if this is the means by which we gain knowledge about the legal system, we're doomed. About the United States, for example, it seems to be an impractical epistemic device. So, that's all I'm going to say about Hart. Dworkin's view of how we know the law requires less reconstruction because his theory of law is at the same time a theory of legal reasoning, and in particular how judges figure out the content of the law in the cases they decide. For Dworkin, the proposition of law is true if it figures in or follows from the moral principles that provide the best constructive interpretation of the institutional history of a community's legal system. The law consists of the set of all true propositions of law. Presumably, the only way one comes to know the content of a given legal system is to successfully engage in constructive interpretation of that system. This involves considering all the relevant institutional legal sources, opinions, statutes, and so on, and by process of imagination and analytical rigor, coming up with a set of moral principles that best fit or justify that legal history, that is, principles that put the law in its morally best light. With those principles in hand, one then determines what legal result follows from them on a particular question at issue. So, in some ways, Dworkin's theory of how we come to know the law is more sophisticated than Hart's. For doing a kind of sociological survey of the behavior of legal officials is only part of one's task in coming to know the law. one has to further formulate and apply substantive and substantively true, I think, moral principles to the sociological data in order for constructive interpretation to be successful. It's in this way that, on Dworkin's view, one's legal knowledge depends in part on one's moral knowledge. And this turns out to be the primary weakness of the theory, as a theory about how we know the law. For one consequence of Dworkin's theory is that despite all our Herculean efforts, we may fail to know the true moral principles that justify the institutional history and the consequences that follows from those principles. But if we're ignorant of those principles, by no means a rare state of affairs, then we're also ignorant of the law in a given community. It follows that the theory allows there to be law that is not just unknown at a given time by everyone in a given community, but given the possible cognitive limitations of the members of that community, there may be law that is unknowable. Dworkin's theory has therefore correctly been called the theory of esoteric law. It's compatible with there being law in a community which no one knows at a given time, and no one will ever know, given their deficient moral knowledge. To be sure, it's no objection to a theory of legal knowledge that one consequence of it is that some, many, or even most members of a given community are largely ignorant about the laws that apply to them. Indeed, this is a common enough occurrence and may be unavoidable in a modern bureaucratic state. But it's another thing altogether to claim that law, by its very nature, may be unknowable by everyone in certain instances. Not only would this make, I think, law into truly queer entities, to adapt J.L. Mackey's remark about mind-independent moral properties, but it would also seem to introduce an element of injustice that is endemic to law. For if any content of a legal system is unknowable to its participants, the existence of law, of such law would run counter to the requirements of the rule of law, one which even Dworkin endorses, that requires that the law be at least knowable to those to whom it applies so that they'll have a chance to cognize it and obey it. The problem with unknowable law would be more severe than in the case of merely secret law, which has recently come in for criticism by Chris Coots and others. The kind of law in question would be, as it were, secret from everyone, because constructive interpretation could not be perfectly executed due to the relevant moral principles being out of our cognitive reach. And not only could this state of affairs be considered acutely unjust, it does not in any case accurately reflect the nature of legal practice. Judges and lawyers, no less than ordinary citizens, render the law intelligible by at least supposing that it's knowable, and perhaps even known by one person or another at one time or another, whether or not they themselves know a particular bit of content in question. Okay, so we've examined two views about how we know the law, as they are implied or followed as a consequence from two leading theories about the nature of law, and have found them both implausible. Hart requires us to essentially conduct full-fledged sociological observation of legal officials to discover what the law is in a given system, and then only as an observer and not as a participant in the system. Dworkin suggests that we know the law by engaging in the austere, complex practice of constructive interpretation, and even then it's not guaranteed that we'll be successful. The law may remain shrouded in mystery because we haven't yet discovered the truth about morality. These views no doubt spring from their respective theories of what law is, and as I stressed at the beginning of the paper, this is just what we'd expect from a metaphysics-first approach. Okay, so I suggest that one strategy in coming to a plausible account of how we know the law is to start with this question, unfettered by any metaphysical commitments about what law is, and perhaps then, guided by that account, we may look to see which of the theories about what law is are most consistent with it, or how existing theories may need to be modified to accommodate it. In what follows, I can only begin to develop such a theory, but my intention is to in part show that such an inquiry is both possible and fruitful, that there's much more to say about it, and legal philosophers have not said it so far. So we can start with an assumption which I think is shared by everyone on all sides, and that's P1 on your handout. The law is knowable. I take P1 to be on the order of a pre-theoretical datum. Hart and Dworkin accept it in one way or another, at least Dworkin wants to accept it, explicitly accepts it, and I know of no theorist who outright rejects it. I have a note about the realists, both of the American and Scandinavian varieties, and I think they assent to P1 as well, but their view is a bit more complicated that I'll just pass over. So absent an argument against P1, let's go to a second thesis, which is P2. For any, on your handout, for any propositional legal content L that exists within a time period, the L is known by at least one person within that time period. Okay? This claim seems as uncontroversial as the first. As I argued earlier, the fact that Dworkin's theory of knowing the law implicitly denies it is the primary reason why it, or any other theory which denies it, should be rejected. Note that P2 does not specify who must know a given instance of legal content. All that's required is for anyone to know the legal content within the time it exists, and moreover to know it for any period of time while it exists. However, it seems likely, perhaps even necessary, I don't know, for at least one person to know a given bit of legal content, namely the person who made it, i.e. the lawmaker. Okay, and we'll return to this point in a moment, but I don't think that's the paradigm case of knowing the law. Okay, so what is the central case? Like, what is the central case of knowing the law? How does a person go about finding out the law in a particular jurisdiction? One might consult texts or other legal sources that one antecedently believes are authoritative. For example, books of statutes, court opinions, and so forth. One may also consult people who one deems particularly knowledgeable about the law, lawyers, judges, perhaps police officers. Depending on one's question, one might resort to inquiring with ordinary citizens within the jurisdiction about what the law is there. And one's choice of which citizens to inquire with may be partly determined by what one wants to know about the law. So, for example, if one wanted to know the law concerning the legal liabilities of employers employing people to construct a building, for example, one would seek out those people that appear to be such employers. Or if one wanted to know the legally enforceable way to buy or sell land in a jurisdiction, one would seek out people who hold themselves out to be real estate advisors, real estate investors, or in the last resort, people who appear to be landowners. Or again, if one wanted to know the common traffic laws or laws concerning jaywalking, you know what jaywalking is? Illegally walking across the street. One might ask anyone on the street, since those laws concern activities engaged in by most people on a regular basis. In short, in inquiring with ordinary citizens about the law, one would seek out as reliable sources people who have an interest in knowing what the law is, which governs a particular activity. As it turns out, all of these possible sources of legal knowledge, expert or not, fall into a single category of knowledge which epistemologists call testimony. Writers on testimony often stress the great importance of the role testimony plays in our knowledge of the world around us and in the role it plays in facilitating all human endeavors. In C.A.J. Cody's study of testimony, a work that revived philosophical interest in the topic about 20 years ago, he points out that, quote, "Many of us have never seen a baby born, nor have most of us examined the circulation of the blood, nor the actual geography of the world, nor any fair sample of the laws of the land. Nor have we made the observations that lie behind our knowledge that the lights in the sky are heavenly bodies immensely distant, nor a vast number of other observations," end quote. And yet we believe and even know at least some of these things on the basis of testimony, on the basis of the word of others. Of course, what's salient for us in this passage is this claim that we know a fair sample of the laws of the land. He seems to agree here with Hart at the beginning of the concept of law when Hart says that, quote, "any educated man will know at least some of the laws of the legal system to which he is subject." But unlike Hart, he suggests the beginning of an explanation as to why this is so. Most people know about the content of at least some laws because they've been told about them by others. But how can the word of others be itself a source of knowledge? Isn't it epistemically irresponsible to justify what we believe on the basis of what people tell us? Shouldn't we instead investigate the things we're told about for ourselves, drawing on the basic, so-called basic sources of knowledge, memory, sense perception, inductive inference? Most theorists of testimony say no. If that were the case, we wouldn't know much, if anything. And this is just Cody's point. Things like science and history, and as I'm arguing also law, would never get off the ground if we couldn't reasonably rely on the testimony of others to know what we know. So what people tell us has to play some role, and an important one in what we know, but what role? The philosophical literature on testimony is very sophisticated, and we don't have to consider the complexities here. But some general sense of the options is necessary for a point I make at the end. So first, a definition of testimony, which I give you on the handout. It's principle DT. So S testifies that P, a proposition, by making an act of communication, A, if and only if in part, in virtue of A's communicable content, S reasonably intends to convey the information that P, or A is reasonably taken as conveying the information that P. Okay, I put this on the handout so you can note how broad the definition is. Okay, testimony on this definition need not involve oral acts of communication, which is how the word is usually used in English, but can take many forms, written, pictorial, and so forth. And with this definition in hand, we should also get the three leading theories of testimony in view. It's interesting that, at least in Anglophone philosophy, this literature dates back to two 18th century Scotsmen, David Hume and Thomas Reid. Right? So Hume gives us this position on your handout I call reductionism, which says justification is conferred on testimonial beliefs by the presence of appropriate positive reasons on the part of hearers, reasons which depend on the other epistemic sources, and that testimonial justification reduces to the justification by these sources. So, for example, if you tell me, someone told me a few hours ago the law school is down the hill and on the right, whether I'm justified in believing that, you might say, at least in that case, is reducible to whether, in fact, my senses tell me that it's down the hill on the right when I look for it. So this is Hume's view. Now, the non-reductionist view is given to us by Thomas Reid, which says positive reasons, that is, reasons independent of the testimony given, are neither necessary nor sufficient for testimonial justification, and testimonial justification is an irreducible source of knowledge. Okay? Like sense perception, like memory, like inference. Okay? Now, a third theory that has been developed by Jennifer Lackey, it's a book from a couple of years ago. She sort of tries to find a middle way and combines elements of both of these positions, which gives us dualism, also on your handout. For every speaker A and hearer B, B justifiably believes that P, on the basis of A's testimony, that P only if, and then she gives us three conditions. B believes that P, on the basis of the content of A's testimony, that P. A's testimony that P is reliable or otherwise truth conducive, and B has appropriate positive reasons for accepting the testimony. Okay. So how do these views in the epistemology of testimony relate to how we know the law? First, given the expansive definition of testimony I gave earlier, notice that on this definition, all of the sources I cited earlier, which one might consult to learn the law in a jurisdiction, would qualify as testimony. Indeed, all of the standard sources of law are written testimonial sources, written court opinions, codes, judicial orders, executive orders, and so on. The ubiquity of legal testimony, as we might call it, given and received among participants in modern legal systems might even lead us to hold the following view, which is P3 on your handout. All knowledge of the law is gained through testimony. If P3 were true, it would run counter to both Hart's and Dworkin's theories, as well as every other theory that I know of, either implicitly or given or implied by most going theories of law. I think P3 is closer to the truth, but it isn't quite right for a point that I mentioned earlier. P3 doesn't reflect the special epistemic relation that lawmakers have to the law that they make. Okay? If law is broadly speaking an institution of authority in which authorized persons create practical reasons with the intention of doing so by the issuing of directives with propositional content, which is I think, part of the Raz's service conception of authority, which is the going theory of authority, then the authors of those directives know their content in the same way they know their own intentions, directly and without observation. And I don't have time to explain what that means, but I defend that in other work. And by the way, we should distinguish between legislators and authors of the law in the sense that I'm using here. So oftentimes in modern legal systems, the people who actually author the content of law and the people who enact it are different people. At least in the United States, most members of Congress don't write the laws that they pass. Lobbyists and law clerks and who knows who else authors the content. But those are the people I'm talking about. In any case, if we make that modification to P3, we get P4. The law is known either on the basis of testimony or, in a small number of cases, in a fundamentally different way, in the case of the lawmakers. Okay, so, but I take the vast majority of cases to be testimony as the means by which the content of the law is known, either by participants or observers who want to know the content of a given legal system for whatever reason. Okay. Recall now the three views I introduced a moment ago concerning the source and nature of testimonial justification: reductionism, non-reductionism, and dualism. Now, I'm not going to try to defend one of these theories against the other. That's another paper. But I want to suggest that if either non-reductionism or dualism is true, in other words, if testimony can, under the right circumstances, serve as a source of knowledge about the matters testified to, then testimony about what the law is can itself serve as a source of knowledge about what the law is in a given system. But if this is so, then the popular strategy of theorizing about the law that I described at the beginning must be mistaken. No legal philosopher, to my knowledge, seems aware that if we can in fact acquire knowledge of the law solely on the basis of the word of others, then the idea that we must know what law is in general before we can know the law in a given community must be wrong. So recall the passage from Shapiro on the back of your handout, which we'll return to now, which sums up the usual strategy. Because legal judgments must track legal facts, a theory that tells us which facts ultimately determine the content of the law will be essential for a theory that tells us how to discover the content of the law. The metaphysics will bear on the epistemology of law. But if the kind of justification supplied by testimony about the law is not reducible to the reasons provided by non-testimonial sources, in this case the facts which would ultimately determine legal content, then there's an important sense in which those determinative facts won't matter with respect to how we, as Shapiro puts it, discover the content of the law. That is, if testimony about the law is by itself productive of legal knowledge, then it simply won't matter whether law is a union of primary and secondary rules, or a set of conventions, or a set of plans of action, or whatever. If, in fact, testimony is a basic source of knowledge alongside, for example, sense perception, then legal judgments might not track legal facts, as Shapiro claims, and yet those judgments could amount to knowledge of the law in a given system. Knowledge of the law would then not require knowledge of its grounds or its ultimate determinants. So to conclude, in a recent interview, George Bush was asked to defend the legality of the interrogation technique known as waterboarding, which he authorized, and a technique which many consider a form of torture and explicitly prohibited by American and international law. But here's how the exchange went with a journalist. Question: why is waterboarding legal in your opinion? And Bush answers, quote, because the lawyer said it was legal. He said it did not fall within the Anti-Torture Act. I'm not a lawyer, but you gotta trust the people around you, and I do. End quote. I suspect many people are inclined to criticize Bush for this response, but if the preceding discussion is generally correct, we should not criticize him for the general way he went about trying to find out the content of the law on this particular question. that is, on the basis of the testimony of another person. He is probably, by the way, open to criticism for not better evaluating the reliability of the testifiers, right? Because it's widely thought that his administration was putting pressure on the lawyers to give them the answers that they wanted, surely a reason to doubt the reliability of the people giving the testimony. But if Bush was not justified in accepting the lawyer's testimony in this case, it serves to highlight the fact that most of us, most of the time, are justified in accepting the claims we hear or read about what the law is in a given jurisdiction in a way that doesn't require us to know the precise metaphysics of the law. Okay, so I've discussed a number of views here which need defending, of course, like non-reductionism and about testimony. But I hope I've said enough to show that which view we accept about the epistemology of legal knowledge matters with respect to the importance we place on developing a theory of the metaphysics of law. For while Shapiro maintains that the law's metaphysics bears on its epistemology, it just might be the other way around. Thank you.